everybody, and welcome to the webinar on custody modifications. I'm attorney Danae Matthews of the Dunn Matthews Law Firm. I am the owner and managing attorney. We are going to probably give it about another minute or so to allow more individuals to come on to the webinar, and then we will get started. So if you guys can just sit tight with us for about another minute or two, we will get started. All right, guys, I want to be respectful of everyone's time today. So again, my name is attorney Danae Matthews, and I am the owner and managing attorney at the Dunn Matthews Law Firm. And you are here today for our webinar on custody modifications, the who, what, where, when, why, and how. And so we are going to jump right in. I first want to tell you guys a little bit about myself, and then we'll talk a little bit about the firm and custody modifications and how we can help you and assist you in obtaining your goals if you are looking to modify your current custody arrangement. And so a little bit about me. I am a wife. I am a mother of three, two boys and a little girl. And I initially came to law school wanting to represent abused women and children. And once I actually got there, I quickly learned that that was not for me. And it was too much of an emotional drain for me. And so I made the decision after one, going through family law courses, and two, seeing the things that were happening with my family members. My brother has 5 children, and he has either one struggled throughout time with visiting them or, child support issues. He has custody of one of his daughters. And then I have uncles who have had issues in the child support, custody, and visitation arena since I was in middle school. And so seeing all of that and experiencing family law and then going through different things such as internships at the juvenile court and seeing families have their children taken away from them, and those types of things made me kind of shift focus and more so focus on helping families, one, become the best unit that they can, given the fact and the circumstances that they are not one unit, right? Either one, they're going through a divorce and they are now separating, but they still have these children that they have to rear and raise and make sure that they are making a great impact upon. And so that became my primary focus in making sure that people can co-parent well and go on their separate lives, but doing it gracefully and with one another, and hopefully impacting their children in a way that they should. And so I started the firm in 2014, the summer of 2014, and we just went from there. A little bit about the firm. We operate mostly on a faith-based representation model is what I kind of like to think of it as. And what that kind of means for me is that we make sure that when representing our clients, we are talking to them about the ways that they can make, one, themselves better, their situations better. And because of that, the end result is that their relationship with their co-parent hopefully becomes better. And so we talk a lot about collaborative litigation. And so I like for a lot of my cases to settle in mediation or outside of mediation with myself and the other side trying to work things out. That way people are making up their own destiny, right? And they don't have a judge interfering with that. And they are able to determine what looks best and works best for their particular family unit. Judges see hundreds of thousands of cases on a monthly basis. And so the Superior Court judges here in Georgia not only hear family matter cases, they hear criminal cases as well, right? And so it's much better if people can work out their issues amongst themselves and not have to bring that third party in. And so we talk a little bit, well, actually quite often about, conceding to things and give and take type of deals, and not everything can be about you and what you want, and you can't focus on the negative things that happened before, because now we're in a position where we need to put your children first and focus on them and making sure that they see two people who, although they may not be together anymore, they can get along, they can co-parent well, and they can be functional, right? And so a lot of the times once our clients leave us, they're equipped to go out and have that relationship with a co-parent that they can text amicably and they're not cursing, screaming with the capital text letters, they're not just being nasty to the other parent. Even if that parent is to them, I give them tools and advice as to how to deal with those situations. And so we kind of focus more on that side of things as opposed to being catty and vindictive. And not having inconsistency with the way that you, one, talk to your co-parent, how often you talk to your co-parent, and consistency with your children. So we don't believe in, being here and then not being here, and calling and then not calling, right? We believe that children should have access to both parents every step of the way. So every single day they should be talking to their co-parent, to your co-parent. Every single day they should be doing something, okay? And that's just what we believe. Very quickly, I just want to let you guys know that by participating in this webinar, we are in no way considered your attorney by you participating, okay? This is simply us giving you legal advice. Not giving you legal advice, but instead giving you different tips that you can use to get your case from point A to point B if you are, in fact, interested in modifying your current custody arrangement. One thing I want to make sure that everyone kind of knows and understands is it's really important for you to understand that we are not your attorney at this point. You can call us for a consultation, and we will get that process started for you. You can sit down with us and we can talk about whether or not, you know, a custody modification is something that you can, in fact, do right now, whether it's something you should do right now or if you should wait to do it. Those types of things we will discuss when you actually come in for a consultation. So very quickly, I want to let you guys know there is a Q&A feature down. It either is one at the bottom of your screen or at the top of your screen. I want to let you know this is my first time doing a webinar. And so although I am knowledgeable of the law, right, and I can tell you legalese every single day, all day, if you needed me to, I am not savvy when it comes to webinars, the internet, just trying to get it all together. So if it seems like I'm a little flustered or if I'm trying to get things together, just know that I really am. And if you just give me a minute, I will be right back in place. So one of the first things that I want to do is a poll, and I want to know exactly where everyone is. And so I want to know whether or not you've worked with an attorney previously. And if you have, great. I kind of want to make sure I'm not spending too much time on things that may be irrelevant to you guys, because you know exactly what it is to work with an attorney. And then obviously you know a lot of the lingo as well. And then I also want to know whether or not you have previously modified a custody arrangement, okay? And so if you have, that again will let me know exactly where everyone is, okay? So I'm gonna give you guys just a little bit more time to do that. And that's just going to allow me to know where everyone is. Right. All right. So it seems that about 25% or so of you have worked with an attorney before. The majority of you have not. And none of you have filed a custody modification action at this point. So that kind of means that I'm going to have to really kind of, let's take this down to grade school level type of thing, because I want to make sure that everyone fully understands what a custody modification entails, and what you should be doing, right, to get your case moving. So I'm going to go back to sharing my screen here. And the very first thing I want to talk to you about is the types of custody. Obviously, if you've already had a custody order, you kind of know what these mean, but I did want to kind of go over these again for you, simply because it's always great just to have a refresher and to, you know, refresh yourself on what these terms mean, so that when you're going into your modification action, you know what you're actually trying to obtain, right? And make sure that you understand that this is Georgia specific. So if you are on here because you saw us on Instagram, or you follow, you like our page on Facebook and you saw the event, I want to make sure that you understand that this is Georgia specific. Every other state may have its own way of doing things. But here in Georgia, this is kind of the way that we do it. And so legal custody in Georgia just means that each parent, once they obtain legal custody, they have the right to make decisions on their child's behalf, and they have the right to be involved kind of in those, day-to-day activities and decision-making processes that are involved when you have children. And so if you are in a position where you're thinking about seeking modification of custody, that means, one, you already have a custody order, right? And so 9 times out of 10, you have a custody order that says that the two of you have joint physical custody. And so joint physical custody simply just means that both of you are able to make those decisions, right? Some people do not have joint legal custody. Some of you may have been in a situation where either you or your co-parent were abusive to the children, or in the marriage in general, or some other thing caused only one parent to have sole legal custody, and you are trying to modify that part of the custody arrangement. That's perfectly okay. And so this webinar is still completely relevant to you, because you'll need to show some other things in order to be able to have sole legal transferred or changed into a joint legal custody situation. If you are, and I just want to put this disclaimer out there, if you are a dad in Georgia and you are trying to obtain custody of your child and you have never been before the court before, and you signed up for this webinar thinking that this webinar was going to assist you in doing that, I want to let you know that at this point in time, if you've never been before the court before, you don't have legal custody, and legal custody is not something that you can currently have, but it can be attained, right? And so right now, the mother is the sole legal guardian custodian until you seek a legitimation action. And so although this is about modification of custody, if you are here and your scenario fits the one I just explained, I urge you to still stay on, simply because the things that we talk about in this webinar are still going to be relevant to you. It's just the way that you will word them when you file your legitimation action to seek legal custody. But for now, again, legal custody is just the right to be involved in those decisions. Where will your child go to school? What doctor will they go to? What extracurricular activities will they participate in? What will their religion be, right? And so those are things that you will have the ability to help make decisions on. And so I urge you, if you're not already talking to your co-parent about those decisions prior to making them, you should be doing that. If someone's on this webinar right now because their co-parent does not talk to them about those things, and so they are trying to seek a modification because of that, that's a huge thing, and that's a problem. You have to talk to your co-parent prior to making those types of decisions, because it can affect your legal custody, potentially. Then there's primary physical custody and joint physical custody. I cannot tell you how many times people come to me and they say, I want sole custody. And I have to ask them, well, what do you mean by that, right? And they say, I want my child to live with me all the time, and that's just it. And they don't understand that there's a difference, right? There's primary physical and there's joint physical. And so really in that scenario, they're seeking primary physical custody. And they either, one, want the non-custodial parent to not have any time at all or limited time, or they don't care if they have 3 weekends a month. It's just that they want to make sure that their child or children remains with them majority of the time. And so in that scenario, you're looking at a primary physical custody scenario, which means that the children are residing with that particular parent 50% or more of the time. And then we have joint physical, where their time is kind of split 50-50 as much as possible. And then obviously in a primary physical custodian situation, the other parent, the non-custodial parent, has something along the lines of maybe 20 to 30% time sharing. And so if you are looking to change from primary physical to joint physical situation, or you're currently in a joint physical situation and your co-parent never, on paper it says joint physical, but they never actually take advantage of that joint physical arrangement, then in that situation, you'd want to be seeking to move from joint physical over to primary physical, because they have shown themselves to, not be an active participant in taking advantage of their current custody arrangement. All right, so we're going to focus a little bit now on where to file your custody modification action. And so I'm going to put up another poll very quickly, and I kind of just want to know where everyone lives in relation to your co-parent, right? Do you guys currently live in the same place, or are you in totally different locations? So if you guys can, I'm going to give you a couple more seconds to answer that question so that I can kind of know where you are with that. All right. Let's see here. Okay. All right. All right, so all of you live in the same county as your co-parent, which is a good deal. 40% of you have a joint physical custody arrangement, and 60% of you, it seems like the children may live with you, if I'm understanding the poll correctly. And so you have to understand exactly where to file your action based off of a couple of things, right? And so you want to consider, where was your last custody action done, right? And so if you are a DeKalb County resident or a Fulton County resident, and your last case and your last order was done in Clayton County, right? Then that does not necessarily mean that you're going to file your action in Clayton County. If neither parent is in Clayton County, there's no good reason why we should be filing our action in Clayton County, right? It doesn't make sense. If we both live in DeKalb County, why would we go all the way to Clayton just to have our case heard? And each of us are having to travel all the way to Clayton. And so the statute supports that by basically saying that you file your modification action in the county in which the person who the children reside with lives, right? So if you live in DeKalb and your co-parent lives in DeKalb, then it's filed in DeKalb County. If you live in DeKalb and your co-parent lives in Fulton, and they are the person who the child resides with, then it's in Fulton, right? If you're in DeKalb, you have the children, then it's filed in DeKalb, right? And so it kind of just depends on where everyone is living, as well as where that last order was done. So you have to consider all of those things because it may have an effect. Typically, we will go ahead and file a custody modification in the county in which the child resides. And that's just the way that we see it better. We have not had any issues with that. And so it, to us, just makes more logical sense to file it there. So moving on, and this part about where to file is not an end all, right? If it's filed in the wrong county, and some of you may have had this scenario, and you find out that someone's objected to jurisdiction and venue, and you were really supposed to file it in full, and it's not the end of the world, right? Here in Georgia, there's a very small fee that you would pay to have your case transferred from one county to the proper county. And that's just something that you would do in the event that you find out that you somehow filed in the wrong county. But typically, the better option is just to file it where the child resides, the custodial parent resides, right? So if, say for instance, you are not the custodial parent, right? You don't have primary physical and you don't have joint physical, so you're the non-custodial parent. And the custodial parent, let's just use Fulton and DeKalb again, lives in Fulton, right? You live in DeKalb, but you've had the children for a year and a half, right? Something happened that required you to take the children for the past year and a half, whether that be a drug issue with the custodial parent, whether that be that they were trying to get themselves together, or maybe they were going to school or working long hours, and so they asked you to kind of take over for a little bit, and now you want to seek a modification because you see that things are improving with the children, or this just seems like a better option for them. Then you run into a very sticky situation, right? But you're not the custodial parent, but the children do reside with you. And so typically in that situation, we would advise our client to file in Fulton County where the custodial parent resides. It does get a little bit iffier from there if your last order was done in a completely different county than Fulton or DeKalb. But that would be saved, obviously, for a more specific consultation-based type of scenario that we deal with there. If you do have a specific question about that you kind of want to get answered very quickly, if I can answer it without being too specific, I will go ahead and put it in the Q&A section, and we'll get to those questions if there are any at the end of the webinar. All right, so a lot of people have to determine, when do I file my action, right? A lot of people are on pins and needles. You know, I feel like this custody arrangement needs to change, but I'm just not quite sure as to how it needs to change, that type of a thing. And so in that situation, you have to think of two things, right? One, has it been 2 years since my last custody action? I have people come to me quite often, actually, and they say, you know, I just had a custody case done. I am not satisfied with the results. You know, this happened, that happened, the judge wasn't listening, you know, their attorney was a jerk, whatever the case may be. And so they then want to seek a modification. And I say, well, when was that last order? And they say, oh, 6 months ago. And that's just not enough. I mean, sometimes in certain very particular circumstances, it very well may be, right? 6 months, and you know, your custodial parent has went on a drinking binge and become an alcoholic and ran into a pole, or had the children in the car while drinking and got a DUI. Something along those lines could potentially end up resulting in a modification being necessary in 6 months' time. But, you know, that's a very rare occurrence, at least for me. And so typically, it's going to be a lot longer than 6 months, maybe a year to 2 years. Statutory law kind of gives us a time frame of 2 years. After 2 years, someone can seek a modification of custody, right? And so I kind of have this chart here where you kind of see the picture going around in a circle, right? And the reason for that being is because it's not simply a requirement that it must be every 2 years, right? Or that it has to be 2 years and that's it. There's no other reasoning to be able to seek a modification, because that's just not the case, right? If it's been a year and a half or a year and there have been some material changes in the circumstances of the children, then that could potentially be enough to result in you being able to file a modification action. And so that material change of circumstances can either be circumstances that have negatively impacted your child in one way or another, or ones that have positively impacted your child in one way or another. And so we will talk a little bit about the types, or a couple of them anyways, material changes that we kind of see often in the courts when people are seeking a modification action. And so we'll talk a little bit about those, but just remember that it's either 2 years or when there's been a material change in circumstances. And material is the really key word here, and we'll talk about that a little bit more when we get to actually filing your petition and what that kind of needs to entail and have in it. And so here we have a couple of material changes that may occur. Obviously, well, not obviously, because it's not obvious to everyone, but given the poll results, but a material change cannot, it may be more than just these 6 things that I have listed here, right? I obviously just kind of gave you a couple of options here. If I were to list all the different things, I would leave out some, which is why you have to schedule a consult with an attorney and talk about your particular situation, because some things are cases of first impression, right? Which means that we or the courts have not seen a case like yours before, because your circumstances and your facts are a lot different than someone else's, right? You may have a parent who's, I don't know, picked up and went across to Israel or something of that nature on a mission trip or something. That's really different, right? And this may be a very limited type of a modification or something of that nature, but everything's case specific. So I've only really listed 6 here today that I kind of want to talk about, that I kind of see more often than not. And so they're in no particular order or anything like that. But first I have here is education, right? And so that material change for education may look something along the lines of, for the past 2 years, custody has been with mom. And for the past year and a half or so, my daughter has made D's, C's, and 2 F's, something of that nature, right? And for the life of me, I cannot figure out what's going on, and mom is not taking her to tutoring. She hasn't signed her up for any tutoring. She hasn't spoken to the teacher or had any parent-teacher conferences about this issue. She has not talked to me about this issue. I only hear about it from my daughter. This is a problem, right? She is in 8th grade. She's going into high school. Things are going to start to get really her grades are going to be really important moving forward, right? Because she's going to be starting to get ready for college in a couple years, those type of things. And that could be a material change, right? Because it's negatively impacting the welfare of the child, right? Her grades continuously decreasing over time and not being resolved, and not someone or the custodial parent not in any way trying to remedy it, right? Still allowing them to talk on the phone or go out with their friends, things of that nature can end up being enough to constitute a material change in circumstance. It could be the other way around, right? If I have a joint physical custody arrangement and I have my child 1 week and the other parent has the child 1 week, and during my weeks, the child's getting A's and B's on tests, but in mom's week, homework, or dad's week, whomever, homework isn't being turned in, projects aren't being completed, which is causing the grades to decrease, or they're always absent from school when they're with that other parent. They're always tardy. And I've noticed a correlation with those things in their grades. Then that's a problem. Or I've noticed a correlation with those things in their behavior, right? My child's being suspended from school, being put in detention, having referrals, in-school suspension. Those of things of that nature are negatively impacting your child. And then when they're with me, they're doing great, and so that's positively impacting them. And thus, I would like to seek a modification of custody so that I can make sure that my child's best interests are taken care of, right, which is the standard that we go by in Georgia. In a custody modification case, first you need to talk about what that material change is and then how it's in that child's best interest. That custody come with you or whatever the situation may be, because of that material change, right? And so education is a really big one because I see it happen time and time again that parents are coming to me because something's happening in school and we need to seek a modification because of it. It's going to hurt my child in the long run, right? Then we'd have diminished health. That could be of your co-parent or of the child, right? And so it doesn't necessarily mean that your child's health isn't being taken care of, but it also can mean that. And so it could mean, I don't know, the custodial parent has placed themselves or gotten placed into a mental institution or some other health problem that they are having. Maybe they've gotten a terminal illness diagnosis or something that's just going to knock them out for 6 months of the year or something, and indefinitely in the long run, we don't know what's going to happen with their health. That type of thing can be a material change in circumstance, possibly. And again, there needs to be a lot more information about your particular set of facts that's going to help us determine whether or not that's a material change. But allergies of children aren't being taken care of. You've got dogs running around your house, and knowing that your child is allergic to that particular type of dog hair or whatever it may be, potentially, given a lot of other facts, potentially may be enough to seek modification. So health is kind of one of those iffy things. You're not taking them to the dentist. They've got 8 cavities in the past year. Whoa, what? That type of thing, obviously, with some other information would potentially be a material change in circumstance, allowing you to modify custody. I want to make sure I say something because I don't think I said it before. Modifying custody does not mean modifying visitation. That's a completely separate thing. And I think we'll talk about it a little when we get to another slide. Relocation is really big when one party's moving for one reason or another. You may be moving from one county to another, you may be moving to another state, but somebody is moving, or you yourself may be moving, and custody needs to be modified because of that. Excuse me. As way of example, if you have joint physical custody and you or your co-parent, both of you live in DeKalb County, right? And then you or your co-parent plan on moving to Cobb County, North Atlanta. If that happens and you have a joint physical custody arrangement, 9 times out of 10, you won't be able to continue with your joint physical arrangement, right? How will you get your children to school when it's your week? How will you get them to their activities that are in the city? How are you going to be able to do that and not have it be a detriment to them and having them wake up at 5 a.m.? We're in Metro Atlanta. All of us kind of know that traffic is not the best, right? Even in a situation where you live in the same county, but you're moving far off. So DeKalb, as we, all of you may know, is one little cluster, right? But then it goes all the way up into like Dunwoody area, over by Perimeter Mall, that type of thing. So if you live over there, right, and then your other parent lives in downtown Decatur, and your child goes to school, let's just say at, I don't know, Decatur High School. I think that's right over there by the courthouse, if I'm not mistaken. It's going to take you a while to get from Dunwoody to downtown Decatur to get your kid to school. And so that potentially may result in a modification of custody. If you have a week on, week off, you may want to try and get something along the lines of a Friday through a Monday or Thursday through a Monday, something that still gives you a substantial amount of time, or your co-parent a substantial amount of time, but it also decreases the amount of days that your child's going to have to wake up extremely early just to get to school at 7-something in the morning at Decatur High School, right? In Atlanta traffic, of all places. We all know our train system isn't that great. There's not something that's going to take them from Dunwoody down into downtown Decatur. And so that's a situation where either yourself, the moving party, or the co-parent is going to file a modification based on that if they feel their child's waking up too early. Or vice versa, you know, if you're moving and you feel, you know what, it's probably best that I get a new custody order, and that way I don't have any issues moving forward, then that's something that you only can do. Child abuse, as we all, you know, I'm sure we all know, child abuse can happen. Child abuse, as far as the modification is concerned, can be by any realm, right? It could be that parent is abusing that child in some form or fashion, or someone in that parent's circle is abusing the child in some form or fashion. So it could mean physical abuse, it could mean sexual abuse, it could mean emotional abuse. Any of those things can play a part in the child abuse section that I'm kind of talking about here. And so that could mean that they are getting spanked excessively. They are being, you know, not given food or a limited amount of food. They are being having demeaning words spoken to them. That parent is just always attacking them in a negative way. Those types of things can equate to child abuse. Leaving them home. You have an 8-year-old and they're always home, I don't know, 8 hours when their parents at work, and it's overnight and they're not supervised, or things like that, although not necessarily automatically thought of as child abuse, right, can be considered as child neglect, right, or unsupervision, they're non-supervised. So that, to me, and in our firm, falls under the realm of child abuse, and that could be enough potentially to seek a modification of custody and be enough to constitute your material change. I kind of labeled these two separately. A child 11 years or older or a child 14 years or older, I labeled separately. And the reason for that being that they have different requirements by statute. And so if you are in a situation where your child is either 11 or 14 and you're thinking about modifying custody, they may be able to have a say, right? I never suggest that you kind of go to your child and have this conversation. You're 12 now, you're 15. Let's talk about who you want to live with. I don't recommend that happening. I think that that's just the absolute worst way for it to happen. I think that if you allow your child to come to you, or if you are noticing signs that things just aren't right, they're not excited to go to their other, your co-parent's home, they're not ready to kind of leap in and hug or talk on the phone with that parent, maybe something's wrong, potentially, right? And so them opening up and having that conversation with you, or once you talk to your attorney, and that person being able to kind of navigate the waters, potentially could result in your child signing an affidavit of election that states who they want to live with. Why do they want to live with that person? And what does that kind of look like, right? And so you don't want a situation where it could even seem in any kind of way that you have forced your child to write this affidavit, or in any type of way told them what to write, or given them the thoughts that they now have, because that could land you in a pretty bad place. But when a child reaches 11, they have the right to kind of elect where they want to reside. It does not mean in any way, shape, or form that that's automatically going to happen, right? That they say they want to live with mom, they say they want to live with dad, and that's what's going to happen. It just doesn't work like that from 11 to 13, right? There's going to be a little bit more that goes into that. And you'd still have to prove that what your child wants is in their best interest, right? Although this is your material change, could be, you still have to prove that this is in their best interest. And judge, you should allow it to happen. But once they reach 14, it's almost presumptive. Like, this is what they want to do. This is what we're going to do. I never go into a case just thinking, oh my gosh, they filed an affidavit, this is what it's going to be. Because guess what? We still have to prove that best interest part of things. And we could still have a situation where a guardian ad litem, which is someone who represents the children's interests and investigates your situation and helps the court to make a determination as to what should happen with custody, that person could potentially still come in even when a child's 14 years of age or older. And they could still be the last person to make that kind of final decision before a judge does, right? They are the judge's ears and eyes outside of the courtroom. And so you just have to remember that when you're thinking about the fact that your child's 11 or 14 and they now are saying they don't want to go over dad's house, or they don't want to go over mom's house. And you have to weed between all the lines of their teenage mindset and figure out whether or not that is something that really should be done, and obviously talk to an attorney before having your child execute an affidavit of election. All right, so proving your material change, is important that you have the things to back you up, right? I mean, you can't just say, oh, they're failing and I don't have anything to back it up with. You need those report cards, right? You want to get report cards from 2 years ago compared to now. You want to get their disciplinary records from the school. Sometimes this can prove difficult, and sometimes it involves a subpoena. Sometimes it involves another extra layer. Someone has to come and testify in court or something of that nature, but it can be done for you to get those records if you don't already keep track of it, right? As a parent, hopefully you're kind of keeping track of things, and you need to be doing that just to protect yourself moving forward. But making sure that you have those report cards, those disciplinary records, and affidavits or something from the school via subpoena to get those things. If you don't have an attorney, you can't do that by yourself. You have to get a subpoena through the court. But if you have an attorney, those are things that we do as a part of your process to get those items for you if you need them and don't already have them. Text, emails between yourself and the co-parent, or texts and emails can sometimes get you in trouble, I guess is how I can say it. So I always tell people, when thinking about using texts and emails to prove your material change, you want to be very careful, right? Like, you can't say that you want to use these texts and emails because of the way that your co-parent is speaking, or the things that they're saying about your child, or the things they're saying about you, which they're probably relaying to your child, or they're not coming to visit X, Y, and Z. And then in those same text messages, you're yelling, screaming, using demeaning words, talking about them negatively, which you may be telling to your children. I'm not saying that you are, but right, like, that's what can potentially be seen from it, and the argument that could be made, right? Or if your co-parent saying, I want my week on, week off, but they're not giving it to me. And you're saying, no, that's not true. They always text me and say, I don't want my visit, or I don't want my week. And this goes both ways for men and women, obviously. But in that situation, if I look at a text or I look at an email and you tell me they have soccer, so you're not getting your week on, week off, they have soccer tryouts all week, that's not me not wanting to get my kids. That's you kind of telling me that this takes precedent. Because of that, I need to hold off, right? And so if that happens consistently over and over again, but you're trying to use it against that person, it could backfire on you, right? So you want to make sure that your own texts and your own emails coming from you are ones that you wouldn't mind being admitted into court, right? Because that's how you're going to prove certain things to the court. It's kind of the same thing that they say about, like, you don't want anything put out there that you wouldn't want to, see on CNN or blast all over the internet, that type of thing. You kind of want it to be as cordial as possible. There are multiple co-parenting apps that you can use. If you follow us on social media, we talked about a couple of those on last week. One of them was Our Family Wizard, and one of them was Talking Parents. Talking Parents, I believe, is $4.99 a month, if I'm not mistaken. And that allows you guys to text back and forth, and it keeps a history of those things. So if your phone breaks or your backup doesn't work, Talking Parents keeps a record of all of those, and they are admissible in court, and it's a low cost. It also has a calendar feature where you guys can keep track of the visits, right? So if you need to say, this person has not been visiting and that's my material change, you have that record from the calendar in Talking Parents or Our Family Wizard to assist you. Our Family Wizard is a little bit more expensive. I think it's $99 for the year, but it's a little bit more comprehensive than Talking Parents, and it has an additional feature, if I'm not mistaken, that allows you to have like a tone meter, and it'll tell you whether or not the tone in your text is a little too much or if you're good, and it can be something that is taken by the other parent as they really want to work with me, right? And not as you're upset. I mean, even though you really are upset, right? But it's not taken off or absorbed as you being extremely upset. So that's a good resource for you guys. Again, if you don't follow us on social media, go ahead and do that. You can find that post about Our Family Wizard and Talking Parents, but otherwise you can certainly look those things up. Just ask Google and it'll come right up. And your co-parent does not have to have the app for you to use the app. I just want to make sure that that's thrown out there. You can use that app as a way to protect yourself and to prepare yourself for proving your material change. Medical records, obviously, that we talked to kind of about the dentist and all those things. So medical records are something that you could get to show that, my kid was bruised when they came back from the other parent's house, or they had a huge burn, or whatever the case may be. Those medical records will help you prove that, and could potentially land you in getting an emergency hearing granted, which we're not covering in this webinar, but that's something that we could potentially talk about. And the affidavits is what we've already spoken about previously as it relates to the affidavits of election. File your action. Basically, as it relates to filing your action, there's a couple of things. I kind of did a little pie chart here because this is kind of the whole pie, and the whole, your case encompasses this whole pie here, right? There are some things that may be in here that aren't in here, right? And that's just because every case is case specific. So there may be some motions added in the middle of all these things. There may be some settlements that happen that aren't in here, but I kind of wanted to just show you guys the whole deal about it. And the one thing I really wanted to focus on is the petition itself. The petition, to me, is one of the most important parts of a custody modification action. And the reason why is because it lays out what your material change is. By not including your material change in circumstances, you could potentially have a situation where you are, your case is potentially being dismissed, right? If there's an attorney on the other side and your petition does not lay out any material changes, then you could leave yourself susceptible to a motion to dismiss, right? And so I always kind of focus on literally putting in the petition, a material change has occurred, such as, and I kind of label it out, or something of that nature, such as, over the past 2 years, my child's grades have went from A's and B's to C's and D's while with their mother or father, whichever one it is, right? Or with the respondent. You really want to lay those things out, and put why then that change in custody is in your child's best interest. You never want to leave out of your petition what your material change is and how it is in your child's best interest. So to change custody. So if it's a grade situation, is in the child's best interest for me to be granted primary physical, or for us to switch to a joint physical arrangement, whatever the case may be, because this will allow the child to have input from both parents throughout the week as it relates to their schoolwork, or because I have the means to offer tutoring, or because I, don't yell and scream. It needs to be labeled better, but I'm just kind of throwing some things out there to you guys, but it needs to be listed. You don't want to give all your eggs away, right, at once, which I typically do not do, but you need to put at least what the things are, and not all the things you have to prove it, but what they are and how it's in the child's best interest to change the custody arrangement. And then obviously you're going to have the person served with the action. You must via either a sheriff or a private process server. So we're talking about a modification here. And so you, once you file your petition, you'd either give it to the sheriff's office by way of the clerk, or you'd reach out to a private process server, or your attorney would if you have one, and we would have that person physically served with a copy of the complaint, which basically starts that case and puts it in motion now. And at that point, you're either requesting temporary hearings or emergency hearings so that custody can be changed on a temporary basis, kind of as a way to either protect your child, or two, to see if this new arrangement is going to work. And before filing your action, it's, you want to really think about whether or not what you're now proposing is what's in your child's best interest and what's going to protect you, because if not, you could potentially run into a situation where you are ordered to pay the other side's attorney's fees. And then we go through discovery, gathering of that information that I kind of talked about, those texts, those emails, some bank statements. If you can show that your co-parent is out doing things that they should not be doing, always buying alcohol, right? And that's shown on their bank statements that they're spending $800 a month. And I'm not just joking. I've had this happen. They're spending a lot of money a month on alcohol. And so in that situation, right, we use their bank records to show that this is what's been happening. So that discovery process and asking for that information, getting things from schools, that type of stuff will assist your case and prepare you for either mediation or trial. This does not mean it goes in this order, right? Petition and service, it goes in this order. The rest don't necessarily go in this order. You may have mediation before you have a temporary hearing. You may do discovery before you have your temporary hearing. So it doesn't necessarily go in this order. Obviously, final trials always last if there is a trial at all. And petition is always first, followed by service. So if you have a couple more questions about that, put in the Q&A, or you can contact us for a consultation, and we'll talk more about your particular situation and how you can go from point A, your preparation, right, that we talked about previously, and getting certain things together on your end, to the petition, all the way to the end of final trial, and hopefully getting you your modification of custody that you're seeking. All right, so here's just a couple of tips for you guys to kind of avoid messing up your case and avoiding the oopsies and all of that because I have a lot of people come to me after they've already started their action and something's gone wrong, or like I said before, they finished an action, now they want to modify, but it's kind of like, oh my gosh, you probably should have spoken to an attorney or hired one at least or something prior to going at it alone. So my first suggestion, obviously, is to hire an attorney, and if you can't hire one, then consult with one, at least consult with one. You will get a wealth of knowledge and learn a lot more about what you need to be doing and how you need to be doing it by consulting, at a minimum at least, with an attorney if you cannot, again, hire one. Keeping adequate records. So again, we talked about those co-parenting apps. Keeping records yourself, just printing out a calendar from Microsoft Word that you can kind of write into what's happening, so that you can keep track of what the records are, what the visits are, and we went to the doctor on this day because of this or whatever. Is a good way to keep track of things. Backing up your texts and emails to the cloud, whether it's iCloud or Dropbox or Box.com, whatever it may be, make sure you're backing up your records, scanning in your children's report cards. And I mean, obviously you don't want to live your life every day by having this record keeping protocol, but you still want to try, when something comes up and you just feel it in your gut, I should probably keep this, then keep that. Phones break all the time. I meet with people in office at a consult. We're looking at text messages, and then they let me know a week later that those messages are no longer here because something happened to their phone. It broke, or it was stolen, or, you know, something. And so it's very important that you back up those things, because once they're gone, they're kind of gone, right? Focus on what's relevant. You don't want to focus on the things that your co-parent has done in the past or what you've done in the past. A custody modification is only about the material change in circumstances that have occurred since your last order. So if your last order was in 2014, we're not talking about stuff from 2013 and 2012. We're talking about stuff from 2014 to 2018 that have either, one, negatively or positively impacted your child and thus resulted in you seeking this modification action. Sometimes it may be relevant to talk about past things, right? Potentially. Their drinking or their, I don't know, smoking habits or their abuse or their whatever was the reason we had our divorce, was the reason we broke up from our relationship. And that's still ongoing. It got better at our last hearing, but like 5 months later, it was right back. Those type of things potentially could cause us to bring in something that happened before your last action. But generally, we're staying in the time frame of your last action to now. And so you want to focus on that. You don't want to focus on the things that your co-parent said about you or what they've done to you or whatever. You want to focus on your child, their best interests, and what things have led to this material change as it relates to them. Be patient, right? The courts are not always this really quick thing, something that's over quickly done. It's a wrap. Sometimes it can be a while. Sometimes it can be 6 months. Sometimes it can be 3 years. Sometimes it can be a year and a half, right? It's never a cookie cutter situation. Things happen throughout litigation, both for you, both for your attorney, the courts, that sometimes we just cannot, as individuals, control, right? And so I urge you to just be patient as you start this process, and just, you know, have faith that what you're doing and the reason that you're doing it is going to work out, because this is what's supposed to happen. And just go with it. Be positive, and don't veer from what you believe to be true. And just make sure that you've prepared it in a way that the court's going to also believe it to be true, right? I listed a couple of resources here that you guys can look into to help you if you don't want to seek the advice or counsel of an attorney. The Fulton County website has a great pro se, meaning someone who is going to represent themselves. They have a great library of documents. Depending on your county, you can just white out Fulton and write your county there. But they have a great library. DeKalb County Family Law Information Center, which is on the first floor of their courthouse. They have a great resource. You can actually schedule a time to speak with an attorney. I do accept cases through them as well. And so you can go there, and they are a great resource as well. You can talk to a paralegal. it's great. Atlanta Legal Aid, they have locations in Metro Atlanta that you can speak to them about your case and how to move forward and the different things that are happening with it. And then obviously there's us, and we are more than welcome to schedule a time with you to come in and assist you with your action. All right. Again, just very quickly, just want to let you guys know that I am not your attorney by doing this webinar. I'm not giving you any legal advice. It's just some tips and tricks for you. Here's our contact information. We will follow up with an email to you guys about, you'll get a recording of this webinar where you can go back and review information if you need to or want to. And we will also be getting out to you guys an infographic that we've prepared for you guys that basically reminds you of the important key parts to a custody modification action. And again, everything's case specific. So if you do have any questions, that you can actually reach out to us directly, and we will assist you in modifying your custody action. So I just have one more poll for you guys. I just want to know, was this helpful to you all? I put yes, no, or a little. Again, this is our very first webinar, so we are really excited to start this webinar series. We will be doing a series of 4 webinars. There will be one every quarter. Our next one is expected to happen in April. So watch out for us again on social media, your email if you're on our newsletter campaign. We will send out information about our April webinar through there and this topic and things of that nature. You also get a link in following up to schedule an appointment with us if you need to. We look forward to assisting you all. I hope that this was helpful to you guys. And that you at least learned a little bit. I can only do so much, right, in an hour in trying to cover a topic that is really case specific. So I hope that you guys got a lot from this. If you guys have any questions, I do have a couple more minutes to answer any questions that you guys may have. Feel free to put something in the Q&A, and I'll wait around for about a minute or two while you guys go ahead and add any questions that you may have. If not, again, I am more than welcome to sit down with some of you guys or have a phone conversation, and we do offer video consults as well. So feel free to contact us at our information on the screen, and we'll be more than willing to help you guys. All right, so if no one has any questions, I don't see any here. Yep, I don't see any in particular, so maybe everybody kind of just wants to keep their stuff private and talk about it later. But I greatly enjoyed doing the webinar. I'm excited to start 2019 and start offering some additional services to everyone in Metro Atlanta. I look forward to you guys being successful in your modification actions, and I hope you guys have a great rest of the day. All right, bye-bye. Have a great day.